Hello, friend. Today we're going to talk about modern slavery and the recent case law in which the court was tasked with safeguarding a child caught in the middle of what could be described as modern slavery. What is modern slavery? Before we go into the case law. Modern slavery is the illegal exploitation of people for personal or commercial gain. It covers a wide range of abuse and exploitation, including sexual exploitation, domestic servitude, forced labor, criminal exploitation, and organ harvesting. Victims of modern slavery can be any age, gender, nationality, and ethnicity. They are tricked or threatened into work and may feel unable to leave or report the crime through fear or intimidation. They may not recognize themselves as a victim. We're going to look at a recent case, the case of Re open bracket, a child, close bracket, open brackets, fact finding, modern slavery, close brackets, reported in 2021 EWFC from page 79. The proceedings concern a child who we shall call child A, who at the time of the proceedings was 4 years old. A's mother is 22 years old and A's father is 28 years old. There is another person who is relevant to these proceedings, and we shall call him BC. He is 41 years old, so we're going to call him Bravo Charlie, BC. A and his parents are Romanian national. Each was born in Romania, and the parents married there in 2016. They traveled to the United Kingdom in May 2019. As European Union citizens, they were up to 30 June 2021 entitled to apply for pre-settled status. On 5 July 2020, A, that's the child, was taken into police protection. On the 8th of July, a few days later, the local authority obtain an emergency protection order with respect to A. An interim care order was made on 20th of July 2020. The issue came before the court for a fact-finding hearing, and the hearing was listed for for a number of days to consider threshold allegation against the parents and BC. Those allegations were contained in a local authority threshold allegation, and the summary of the allegation include the following. A, or 1, violence by the father against the mother in the presence of A, the child. B, rough handling of the A, or the child, by BC. C, or number 3, violence by BC against the mother. D, or 4, rape perpetrated by BC against the mother. E, or 5, coercive and controlling behavior by BC against the mother. And F, an incident on 30th June 2021 which is said to include a serious assault of the mother by BC and another man, an attempt by BC to force the mother into prostitution, and an event which amounts to the modern slavery of the mother by BC. We're going to jump straight to the legal framework, skipping the evidence, because just to emphasize the legal issues that the court considered. Firstly, the court established or noted that the burden of proof lies upon the local authority in respect of the allegation that were made against the parent and against BC. The standard of proof is the balance of probabilities as stated in the case of Reby children reported in 2008 UKHL. There is no burden or pseudo-burden on the lay parties to provide an explanation for any disputed allegation or to prove that the allegation is false, and that was established in the case of Lancashire County Council against D&E, reported in 2010 to FLR from page 196. Similarly, emphasized in the case of C&D, photographs of injuries reported in 2011, 1 FLR 990. The court went on to say that the essential need for a link between the parental behavior identified and the statutory requirement of Section 31 Children Act 1989 were emphasized in the case of J, open bracket, close bracket, a child, reported in 2015 EWCA CIV 222, where the court states that it is vital that local authorities and, even more importantly, judges bear in mind that nearly all parents will be imperfect in some way or other. The state will not take away the children of those who commit crimes, abuse alcohol or drugs, or suffer from physical or mental illness or disability, or who espouse antisocial, political, or religious beliefs simply because those facts are established. It must be demonstrated by the local authority in the first place that the reason of one or more of those facts the children has suffered or is at risk of suffering significant harm. The court defined domestic abuse, coercive behavior, and controlling behavior as defined in Practice Direction 12J as follows. Domestic abuse includes any incident or pattern of incidents of controlling, coercive, or threatening behavior, violence, or abuse between those aged 16 or over who are or have been intimate partners or family members, regardless of gender or sexuality. This can encompass, but is not limited to, psychological, physical, sexual, financial, or emotional abuse. Domestic abuse also includes culturally specific forms of abuse, including, but not limited to, forced marriage, honor-based violence, dowry-related abuse, and transnational marriage abandonment. Coercive behavior means an act or pattern of acts of assault, threats, humiliation, and intimidation, or other abuse that is used to harm, punish, or frighten the victim. Controlling behavior means an act or pattern of acts designed to make a person subordinate and or dependent by isolating them from source of support, exploiting their resources and capacities for personal gain, depriving them of the means needed for independence, resistance, and escape, and regulating their everyday behavior. The court then went on to deliberate on the issue of modern slavery. The local authority alleges that the event of 30th June 2020 constitute modern slavery, and as such was seeking finding in those regards. The court went on to look at the statutory definition of the offence of modern slavery as set out in Section 1 of the Modern Slavery Act 2015. Slavery, servitude, and forced or compulsory labour, subsection 1 of Section 1 states, a person commits an offence if, open brackets, A, the person holds another person in slavery or in servitude, and the circumstances are such that the person knows or ought to know that the other person is held in slavery or servitude, or B, open brackets B, the person requires another person to perform forced or compulsory labour, and the circumstances are such that the person knows or ought to know that the other person is being required to perform forced or compulsory labour. Subsection 2. In subsection 1, the reference to holding a person in slavery or servitude or requiring a person to perform forced or compulsory labour are to be construed in accordance with Article 4 of the Human Rights Convention. Subsection 3. In determining whether a person is being held in slavery or servitude or required to perform forced or compulsory labour, regard must be had to all circumstances. Subsection 4. For examples, regard must be had to A, any of the person's circumstances, open bracket, such as the person being a child, the person's family relationships, and any mental or physical illness, close brackets, which may make the person more vulnerable than the other persons. Subsection B. To any work or service provided by the person, including work or services provided in circumstances which constitute exploitation within Section 3, subsection 3 to subsection 6. Subsection 5. The consent of a person, open brackets, whether an adult or a child, close brackets, to any of the acts alleged to constitute holding the person in slavery or servitude, or requiring a person to perform forced or compulsory labour, does not preclude a determination that the person is being held in slavery or servitude or required to perform forced labour or compulsory labour. The relevant part of Section 3 defines exploitation as follows. Sexual exploitation, subsection 3. Something is done or in respect of the person, A, which involves the commission of an offence under subsection 1, section 1, subsection 1A of the Protection of Children Act 1978, open brackets, indecent photographs of children, close brackets, or 2. Part 1 of the Sexual Offences Act 2003, sexual offences, close brackets, as it has the effect in England and Wales, or B, which would involve the commission of such an offence if were done in England and Wales. Removal of organs, etc. Subsection 4. The person is encouraged, required, or expected to do anything, A, which involves the commission by him or her or another person of an offence under Section 32 or 33 of the Human Tissue Act 2004, prohibition of commercial dealings in organs and restriction of on use of live donors, close bracket, as it has effect in England and Wales, or B, which would involve the commission of such an offence by him or her or another person if it were done in England and Wales. Securing services, etc., by force, threat, or deception. Subsection 5. The person is subjected to force, threats, or deception designed to induce him or her A, to provide services of any kind, B, to provide another person with benefits of any kind, or C, to enable another person to acquire benefits of any kind. Securing services, etc., for children and vulnerable person. Subsection 6. Another person uses or attempts to use the person for a purpose within paragraph A, B, and C of subsection 5, having chosen him or her for the purpose on the grounds that A, he or she is a child, is mentally or physically ill or disabled, or has a family relationship with a particular person, and B, an adult or person without the illness, disability, or family relationship would be likely to refuse to be used for that purpose. Article 4 of the European Convention on Human Rights prohibits slavery, servitude, and forced or compulsory labour. Guidance in identifying and supporting victims of modern slavery have been produced by the Home Office pursuant to Section 49 of the 2015 Act. Modern slavery includes trafficking, but also encompasses cases of slavery, servitude, and forced or compulsory labour. The guidance further provides as follows: forced or compulsory labour, open brackets, victim not trafficked. United Nations Convention number 29 concerning forced or compulsory labour defines forced or compulsory labour as all work or service which is exacted from any person under the menace of any penalty and for which the said person has not offered himself voluntarily. The 1926 Slavery Convention defines slavery as the status or condition of a person over whom any or all of the powers attaching to the rights of the ownership is exercised. The concept of ownership is what makes slavery distinct. For example, a situation where an individual was being controlled by another would not meet this threshold unless there was clear evidence the person was being used as a commodity. It is a form of servitude with the additional concept of ownership. This section gives further guidance on the component that apply to victims of slavery. Servitude and forced or compulsory labour, where the victim have not been trafficked, means and service. Under means, the threat of a penalty may be the threat of physical violence or restraint, but it can also be of a psychological nature, such as a threat to denounce victim to the police or immigration authorities. Consent is a factor, but a victim may have been given consent in a situation where they felt they had no viable alternative, in which case they could still be subject to force or compulsory labour. Governmental guidance further goes on to say that there does not necessarily have to be a direct personal relationship in psychological cohesion. It could refer to wider issues, for example, social stigma. This is particularly relevant in cases involving sexual exploitation or other forms of sexual violence. Other examples include A. Grooming, where individuals are enticed over time to take part in activity in which they may not be entirely willing participants. For example, the boyfriend method is fairly common in sexual exploitation. B. The Stockholm Syndrome. By the Stockholm Syndrome, we mean where, due to unequal power, victims create a false emotional or psychological attachment to their controller. In both cases of these examples, the individual can often first appear to be a willing participant. Due to their age and dependent status, children are especially susceptible to physical and psychological cohesion. At paragraph 2.95 of the guidance, a number of myths or common misconceptions about modern slavery and its victims are set out. Of particular relevance here is a myth that just because the person does not take opportunities to escape, it means that they are not being coerced. There are many reasons why someone may choose not to escape an exploitative situation, including fear of reprisals, vulnerability, Stockholm Syndrome, violence or threat of violence, and not knowing how and where to seek help. Another myth is that it cannot be modern slavery when organizer and victims are related, married, living together, or lovers. It is said that close relationships are often used to exploit and control others. This is especially relevant in child modern slavery. There have been numerous incidents where boyfriends have groomed women and children into sexual exploitation, or family members have colluded intentionally or unintentionally in the exploitation. It is also the case that some people are willing to tolerate their situation because they may perceive it as a stepping stone to a better future and may compare it favorably to experience at home. This does not mean they are not a victim of modern slavery, and that it is not uncommon for victims to reject offers of help at first. This is not unique to victims of modern slavery. The court went on to state that a national referral mechanism has been established to identify victims of modern slavery. Upon referral, the single competent authority will make a reasonable ground decision within 5 days of referral, and then conclusive grounds decision no sooner than 45 days later to determine whether, on the balance of probabilities, there are sufficient grounds to decide that the individual is a victim of modern slavery. In this particular case, the court went on to make various findings, but the emphasis of this video is to bring to the forefront the issue of how the court considered modern slavery and whether the court, in fact, made any findings in relation to modern slavery. We shall now turn to the conclusion and the decision made by the court in this particular case. The court went on to say that the local authority pleaded its case on modern slavery, focusing solely on an event or events which took place on a particular day, the 30th of June 2020. The essence of forced or compulsory labor under the United Nations Convention 29 is work or service which is exacted from any person under the menace of any penalty. As the guidance says, for a person to be a victim of forced or compulsory labor, there must have been two basic components. First, the means. By means, it means threat of penalty, for example, threat or use of force, coercion, abduction, fraud, deception, abuse of power, or vulnerability. And the second is service. As a result of the means, an individual provides a service for benefit, for example, begging, sexual services, manual labor, or domestic services. The court went on to state that the event of 30th June 2020 satisfies the means element. That's the first element, means, as in MEANS. The court concluded that there was, on that occasion, a considerable abuse of power exercised by BC over the mother who was vulnerable. There was also the threat and use of force and the use of coercion. The court, however, was not satisfied that the mother provided a service. The service element requires the mother to have done something as a result of the violence and coercion she had been subjected to. Had she provided BC or BX with a sexual service as he was requesting, then the service element would have been met. However, the mother refused to do so. In this particular case, the court refused to be drawn into the wider ramification or the wider terms that the relationship between BC and the mother crosses the boundary from cohesion and control into modern slavery. The wider point was not pleaded by the local authority against BC, and it will not be fair to him to broaden significantly the scope of the schedule of allegation at this stage. The court, however, went on to make findings that the event of 30th June 2020 placed the mother at risk of modern slavery. BC arranged for BX to attend the mother's home with the suggestion that the mother would be willing to provide him with sexual services for reward. Had she done so, the service element of forced and compulsory labor would have been met. The court therefore only limited the findings to the fact that the events of 30th June 2020 placed the mother at risk of modern slavery. The court then went to tie the findings to Section 31 threshold and how it has affected the child A. The child A has been exposed to arguments and violent incidents between the father and BC. Most significantly, he has been exposed to the cohesion and control and the sexual and physical violence perpetrated by BC upon the mother and the aftermath of the incident of violence. That violence was escalating in the weeks leading to the incident on 30th June 2020. In this particular case, the case goes into detail how the various laws of modern slavery are applied in family proceedings. And in other cases where there is cohesion and violence, there's potential for modern slavery. Those involved in child protection need to be alert, and this is my own addition to the judgment, need to be alert to abuse, which includes modern slavery. I hope you have found this helpful, and should you wish to read more about this case, I will provide you the reference again, and it's A open brackets a child close brackets open brackets fact finding colon modern slavery close brackets reported in 2021 EWFC from page 79. Thank you.